Okay, welcome everyone. I'm really pleased to see all of you here today and for this last in our series of faculty talks. This particular one is on reproductive rights, and we have with us two really interesting panelists, Kimberly Mutcherson, who is our professor and co-dean down in Camden, and Kate Doyle, who is a student who is involved in some of the student organizations that are working on these particular issues. So what I'm going to do first is ask them to introduce themselves, tell you a little bit about their background, and then we'll get into the topic. So Dean Mutcherson, you're first. Go ahead.
Perfect. Thank you so much for letting us do this, Anita, and thank you to all the folks who are listening in today. So my name is Kim Mutcherson. I'm the Dean of the Law School down in our Camden campus, so I'm closer to Philly for those of you who might not be from the area. And I have been doing reproductive rights / reproductive justice work for some decades now. I was talking at a conference the other day, and I said that the first abortion rights march I went to, I was in high school. So it's been quite some time. And I both write and teach in the reproductive justice area. And we'll talk a little bit once we get into some of the substance about why I'm using reproductive justice instead of reproductive rights. And my work mostly is on abortion, assisted reproduction, decision-making for pregnant women and pregnant people. And I also do bioethics. So I'm sort of a health law, bioethics, family law person who mostly focuses on reproductive justice. So I'll leave it there and turn it over to Kate.
Great, thank you. Go ahead, Kate, you're next.
Hey y'all, congratulations on being accepted to Rutgers Law. It's a pleasure to be here today. So my name is Kate Doyle and I use she, her pronouns, and I am originally from Richmond, Virginia, and prior to law school I had no experience living in New Jersey or really spending any amount of time in New Jersey. And I am really pleased to have spent the last roughly 3 years in Camden. And a little bit about me. Prior to law school, I worked for roughly 10 years post undergrad studies. And I went to a small liberal arts school in Virginia, Christopher Newport University, if that's ringing any bells for anyone. So really teeny tiny compared to Rutgers University. I graduated from there in 2012, started here in 2019. The first in my family to go to college, and one of the first in my family to graduate from high school. And I am one of 5 children, and access to reproductive health care and all that reproductive health care entails really kind of shaped my family life, and at a young age began to kind of see the intersection of like economic justice and reproductive justice, but didn't really have the language for that. And later on, post undergraduate studies, I had an administrative job at a Planned Parenthood affiliate, where I really began to see the ways in which the state can control people's access to reproductive freedoms, and that led me to law school ultimately. So here I am, and I'm not entirely sure what my post law school life is going to look like, but I'm hoping to pursue a fellowship in reproductive justice. So that's a little bit about me.
Great, thank you so much. For people who are listening in, if you have questions along the way, you can throw them in the Q&A or throw them in the chat. We'll be monitoring both the Q&A and the chat and make sure that we bring those questions into the conversation. So now I'm going to turn it over to Dean Mutcherson.
Great. So my hope is that this can be really a conversation. I like to say that I'm a lawyer who doesn't love the sound of my own voice. I actually like to have exchanges with people. So hopefully you all will have some questions and we can do a little bit of back and forth. So I want to talk sort of broadly, one, about reproductive justice, and two, about sort of where we are in this moment. And then I also want to give Kate a chance to talk about some of the work that she's done here at the law school with our If, When, How chapter, and then also some of the legislative work that she's done with some of her colleagues, which is really just quite extraordinary. So reproductive justice, when we talk about reproductive justice, it is a idea, a movement, a theory that was created by Black women in the 90s. And the idea was that the reproductive rights movement, which had, for the most part, been run by white women, and in particular, middle to upper class white women, was not sufficiently broad to capture the range of issues that are relevant to a broader range of women, right? And so the idea of reproductive justice was really to expand the lens of the work that we're doing in this sort of reproductive space. So reproductive justice basically rests on three tenets. The first is the right to have a child. The second is the right not to have a child. And the third is the right to raise your children in safe and healthy environments. So just from that, you can tell that reproductive justice is much more expansive than reproductive rights, right? So it's about, obviously it's about access to contraception and abortion, but it's also about reform of our child welfare system and environmental justice and criminal justice reform and voting rights, right? It's the whole gamut of things. So it's a really interesting space in which to do work, because there's lots of opportunity to think across issues and to work in coalition with people, which I like to do. But let me, even though reproductive justice is not solely about abortion, that's one of the really important things about how it differs from what a lot of our conversation about reproductive rights is. We are in a moment where it makes a lot of sense to talk about abortion and abortion access in the United States. And so let me just give a little bit of background in order to make it clear why we are in this really difficult and I would say dangerous moment for abortion rights in this country. So Roe versus Wade, right, major case decided in 1973 by the US Supreme Court. And in that case, the court came down pretty strongly on the idea that the Constitution definitely protects a woman's right, and I'm going to say woman because that's definitely what they were talking about in Roe versus Wade, a woman's right to terminate a pregnancy. If you ever read Roe, one of the things that's a little off-putting about it is that it focuses not so much on women as it does on doctors, which was a deliberate choice by the justices when they did that, because they wanted an opinion that was going to be very sort of based in medicine and science and really objective. Which, nice try and all that good stuff. So what they decided in Roe was essentially that in the first trimester of pregnancy, states couldn't regulate at all. In the second trimester of pregnancy, they could regulate in order to protect the pregnant person. And then in the third trimester of pregnancy, they could go as far as to ban abortion altogether, but there always had to be an exception for the life or health of the pregnant woman. So that was Roe. Then in 1992, we got Planned Parenthood versus Casey, which actually came out of Pennsylvania, so right across the border from where we are down here in Camden. And Casey was the first case that really substantially altered what the court had decided in Roe. And so what the court said in Casey was, yes, women have a right to terminate a pregnancy, but we have not been giving enough credit to the state's interest in potential life. And so Casey, at least if you are believing the justices, was really about sort of swinging the pendulum back a little bit so that the state's interest in potential life could also be protected. So what the court said in Casey is, this whole trimester framework, totally useless. We're not going to use that anymore. We're just going to worry about viability. And then we're also going to change the test, right? So the test that's going to be used by courts to decide if a new statute, if a new law is constitutional or unconstitutional. And they created this standard called the undue burden standard, which has basically been used as a tool to continue to scale back on abortion rights in the years since 1992. So in Casey, the court decided that states could have waiting periods right? So in Casey, it was a 24-hour waiting period. They decided that states could have biased informed consent requirements, right? The state could say, this is exactly what your healthcare provider has to say to you if you're going to terminate a pregnancy. It said that young women who are minors, that their parents could be either required to be notified or even to give consent, as long as there was a judicial bypass procedure. And so Casey was really the case that sort of moved us into the space that we are in now, which is a space where, you know, as much as we can have concerns about what's going to happen in Dobbs versus Mississippi, the truth is that there are lots of people in this country who already don't have access to abortion. You know, Mississippi has one abortion clinic left. They're not the only state that has so little access. So if you're poor, if you are an undocumented immigrant, if you are living in a rural area, if you're young, right, there are all sorts of ways in which access to abortion has already been significantly constrained in this country. So over the last several years, there have been a series of cases that have gone up to the Supreme Court that are abortion cases. And in all of those cases, the court has come out saying, you know, we might still be willing to tweak it, but there is a constitutional right to terminate a pregnancy. And then we got some new justices on the Supreme Court. You know, nothing has changed in the law, nothing has changed in science. The only thing that has changed is the new justices on the court. And so they took this case, Dobbs versus Mississippi, which is a 15-week abortion ban from Mississippi, which is patently unconstitutional under existing precedent, right? Under Roe and Casey, a 15-week ban is too early because it is before viability, and therefore it should be unconstitutional. The expectation of lots of us who do this work is that the court is going to take this as an opportunity either to sort of get as far to the line as possible in terms of not overruling, but getting as close as possible to that, or quite frankly, just overruling Roe versus Wade and Planned Parenthood versus Casey. And before I sort of turn it over to Kate, the thing that I think is really important for people to understand is what happens if Roe gets overturned. So the first thing that happens is that the US Constitution no longer protects a right to terminate a pregnancy, right? And so what that means is it gets thrown back to the states. So you could have just a complete patchwork of where you can get an abortion in this country. There are many states, in fact, over half the states, I think at this point, already have trigger bans in place, which means as soon as Roe gets overturned, the abortion will be outlawed in those jurisdictions, so they don't even have to do anything. And then we have a bunch of states, if you're paying attention to the news, states that are right now passing new statutes to make abortion illegal in anticipation of what's going to happen in the Dobbs decision. And then we have other states like New Jersey, which fairly recently passed a Reproductive Freedom Act, right, to make it very clear that you can have access to an abortion in New Jersey, and also talking about being able to fund access to abortion and contraception. So what we can imagine happening, and we're probably going to get a decision from the Supreme Court in June. So it's a little bit away, but not that far. So what we could imagine happening is Roe either gets totally overruled or partially overruled, and then we just start to see a flurry of legislation, some good, some bad, but we also start to see what the world looks like when you have to create a network of access, because there will be lots of people in states where they don't have access. And the last thing that I want to say is that, you know, we're in a very different world than the world that we were in 1973. And in particular, we're in a world where there's access to medication abortion, which of course you can get early in your pregnancy, in the first 10 weeks of your pregnancy. And so one of the things that we're going to see that's really interesting is how states try to control access to medication abortion. So, you know, making laws that say you can't send pills across state lines to someone. We just saw, I can't remember what the state was that already is thinking about a statute that will make it illegal for people to cross state lines to get an abortion, which is totally unconstitutional, right? There's no way that should stand. So it's going to be a really bumpy ride. And in particular, it's going to be a bumpy ride because the rationale for Roe and Casey is rooted in privacy. And so if what the court says in this case is, you know what, this whole privacy jurisprudence that we've come up with, who needs it? Well, I can tell you what else has been protected by the right to privacy. The right to access contraception, the right to marry, the right to make decisions for your children, right? All of those have been looped into the idea of a right to privacy. So if we lose that, even if you don't care about abortion, the dominoes that potentially fall after that should definitely concern you. So let me leave it there. And then if there are questions, obviously, feel free to post them in the chat. But I also want to give Kate time to talk about the work that she does in the law school. And if you're comfortable, Kate, talk about some of the work that you did with the legislature, which had such a great outcome recently.
Thank you so much for that, Dean Mutcherson. And I did just drop in the chat a link that I'll talk about in just a moment as well. And I think it's Michigan, maybe, that's imposing the travel ban for folks that are planning on traveling out of state to access necessary abortion health care. So yeah, If When How, Lawyering for Reproductive Justice is we're a chapter that's part of a national organization. And I think that there are over 100 chapters based out of law schools. And the Camden chapter is a relatively new organization. And some of the work that we're doing, I think the overarching concept, and one of the things that I'm most proud of is to tie back to one of the things that Dean Mutcherson kicked off our conversation with, is just starting the conversation amongst law students that reproductive justice is the framework that we need to be having these conversations in, right? So there is a whole world beyond reproductive rights. And if we've achieved anything, I think that that's what I'm most proud of, is getting folks to be creative and mindful of the fact that that's not where the conversation ends. That's just a piece of it. And there are so many intersections, right? So if you don't have access to healthcare, reproductive healthcare, then your access to economic justice and family law matters, like family welfare generally, and mental health, those are all going to be cut off. So I'm also happy that we've been able to get folks to start speaking in more gender inclusive terms. So you've heard Dean Mutcherson talk about pregnant people as opposed to just women. That's not a move that the court has embraced, but that's something that we as a chapter and as If When How nationally has really been working towards. So some of the things that action-wise our chapter has worked on previously and is continuing to work on. So we've hosted quite a few panels. Dean Mutcherson has regularly been a panelist for us, but one of the panels that I think was most exciting was about the Hyde Amendment. So Dean Mutcherson talked about how the right to abortion has just been kind of a fluffy word and not actually a right for so many people in this country. So, you have Roe v. Wade, but it's kind of meaningless. And the Hyde Amendment is one of the reasons for that. So that Hyde Amendment prohibits federal funding. So if you receive Medicaid or Medicare or TRICARE, then you, very generally speaking, can't use any of those plans towards abortion care. And I think a lot of folks don't generally realize that. And so we had an abortion provider, the executive director of our local abortion fund, as well as a lawyer who defends abortion providers, come speak to students about the implications of the Hyde Amendment on poor folks and folks who receive government-backed insurance. We have implemented a couple of annual programs like a coat drive for unhoused sex workers in Philadelphia. And I think one of the things that we're probably best known for across campus and across Rutgers generally is traveling to the Supreme Court for the two big, most recent abortion cases. I think as law students, as the future lawyers of America, we are stakeholders in the outcome of these cases. And it's important to signify to not only Supreme Court justices, but to the country at large, that as the future lawyers of America, we stand in solidarity with folks who seek abortion care, and we stand in solidarity with abortion providers for a variety of reasons, because abortion leads to better futures for people who need abortion, for people who want abortion. And it stands for someone's ability to thrive, for them to be able to create the reproductive future that they want. And so we have gone to the US Supreme Court for the June medical services hearing, and also for Dobbs, and demonstrated outside of the US Supreme Court on both of those occasions. And let me just say, no small feat, getting 15 to 16 law students from New Jersey to DC and back in one day, but something very proud to have done. And Dean Mutcherson, is there something else specific to If, When, How that you'd like me to talk about?
No, I think that's good. But if you do want to talk about the legislative stuff, that would be great too.
Yeah. And I think one of the really unique courses that Rutgers offers, and I have not heard of a ton of other law schools offering any sort of coursework quite like this. So my 2L year, I took a course called Legislative Policy Drafting, and worked on a bill which did prohibit the practice of non-consensual invasive body exams in New Jersey. And some of you all may have heard of this practice. For those of you who have not, it's shockingly fairly routine for medical students to learn how to perform pelvic exams and prostate exams and breast exams on patients who are under anesthesia and teaching hospitals without those patients' knowledge or consent. So if you go to a teaching hospital for a colonoscopy, we'll say, while you're under anesthesia, there is a possibility that 5 or 6 medical students will line up and learn how to perform a prostate exam on you if you were a male, or a pelvic exam on you while you were under anesthesia without your consent. And while I was in this course, 2 of my classmates and I read through a proposed bill that had been pending in the New Jersey legislature forever, and crafted some really specific amendments, submitted them to the legislators who had been working on this, and really started pushing this bill through the legislature, and were able to get these bills heard and eventually passed. And New Jersey is now the 16th state to prohibit this practice in medical school learning. Yay. So you all can all safely go have surgery under anesthesia in New Jersey without fear of having these practices done on you. And, you know, I think that this not only speaks to bodily autonomy, but also this practice is part of a long legacy of exploiting bodies, specifically women's bodies, specifically poor women's bodies, for the sake of medical learning, and who doctors are generally largely privileged white men. And this was just a very small step in breaking that chain of history. So it was very exciting to be a part of that.
And Kate also testified in front of the legislature. So it was a really extraordinary project, and one of those opportunities to remember what's possible, right? When you're willing to advocate, and when you know what's going on, right? Because I think a lot of people had no idea that this was a common practice at medical schools and teaching hospitals. And it's sort of horrifying to realize that it's been going on for years and years. So that's our sort of, you know, official piece here. But Kate and I are both, you know, here for the duration. So if there are questions that people want to talk about, I'm also happy to talk about some of the other work that I do. And then I think there's a question in the chat. Oh, so the question is, I know a lot of states have put in place prescription drug monitoring programs to track all prescribed medication. If Roe is overturned, do you think that the states where abortion is likely to be banned or severely restricted will turn to drug monitoring programs to restrict and prosecute people and physicians who obtain and prescribe medical abortion drugs? So I'm going to say I have a couple of thoughts on this, and then Kate, you should also jump in if you want to. So one of the things that I will say, that's going to be really interesting in the months post Roe, and I'm just talking about it that way because I'm like preparing myself mentally, is there has been a very long history of people who are pro-life or anti-choice taking the position that that if there's going to be punishment, that punishment should be for abortion providers, right? That you shouldn't go after a pregnant person, that, you know, the pregnant person is, you know, maybe being manipulated. And so you should feel sorry for them, but, you know, the providers are the people who you should go after. And there have obviously been exceptions to that. You know, women being prosecuted for miscarriage management, you know, that kind of thing. But I think one of the things that we're likely to see in a post-Roe world is an increase in laws and practices that go after people who are actually having abortions, not necessarily people who are providing abortions. And medication abortion is a perfect place to start doing that, right? So you go after somebody because they filled a prescription, you go after somebody because they drove over state lines to purchase a prescription. You, as you suggest, Catherine, you know, you figure out who is, you know, providing these medications to people. Somebody shows up at a hospital and you're suspicious that they used abortion pills, you know, that person potentially gets arrested. So I think that there are lots of interesting ways in which the landscape of how people get identified and potentially punished for accessing abortion will shift in a world where Roe doesn't exist anymore. So, Kate, did you want to add anything to that?
Sure. I don't have anything like terribly substantive. I do think that one thing that I've seen a lot of is well-intentioned folks sharing like memes and potentially harmful messaging, not realizing that it's harmful, like wire hanger kind of things, like we're going to go back to this, not realizing that, you know, we have come such a long way since 1973, and that abortion via pills, this is a thing. This is a reality, and it is accessible. And you know, if you're going to be sharing something like a meme, what you can be sharing is how to access that kind of care. And for folks who are going to be experiencing in access, you know, whether they live in a rural area, whether they live in one of these 26 states that have trigger laws on the books, trigger bans on the books. If you were one of those folks, what would you rather see? One of these like coat hanger memes, or information on how do I access abortion pills now? And so that goes back to the website that I linked earlier, reprolegaldefense.org, and this link that I'm going to drop now. And this is all that I'm going to say about that, because I am not past the bar yet. And there you go. And that's that on that.
Yeah. The other thing that, you know, potentially we're going to see is a lot more state level action. And what I mean by that is that every state has its own state constitution, which people don't necessarily know. And some of those state constitutions are actually significantly more expansive than the US Constitution, right? And actually speak, you know, the word privacy doesn't appear in the federal constitution. It does appear in some of our state constitutions. Some of our state constitutions have much stronger protections against gender discrimination, right? And much stronger protections about equality. And one of the sort of decisions that was made early on in the abortion rights movement was to focus on the sort of privacy and fundamental right issues, and not so much on the equality question, right? And the equality of question, of course, is are women able to live their lives in the most fulfilling way possible if we do not have access to tools of avoiding pregnancy when we don't want to be pregnant, or terminating pregnancies when we don't want to be pregnant, right? That's the equality argument. And that's just not the argument that sort of stuck early on. And so one of the things that might come back is, you know, more state litigation, right? People are just going to sort of throw up their hands and say the federal courts are not available to us anymore. And so you'll see more state legislation, more state litigation. It will be litigation under state constitutions. And perhaps more of it will be about equality and not about privacy. And that'll be interesting to see. I mean, we're already in this space where we're starting to see courts thinking in more complicated ways about gender and gender identity and sex equality. So, you know, if you're trying to find some silver linings, and they're a little hard to find, but if you're trying to find some silver linings, it might be that we get a much more interesting and fulsome discussion about sex equality that comes out in a world after Roe, and that could be potentially a positive thing. We'll see.
One thing I wanted to add is, if you are interested in getting the insider view of how state legislatures work, the Eagleton Institute, which is a graduate institute on the New Brunswick campus, offers fellowships for graduate students, and they have generally about 25 of them that they give out, and usually anywhere from 8 to 10 law students end up becoming Eagleton Fellows. And what that means is, in your third year, you would do a seminar in the fall semester that would be in New Brunswick, but it is based on state government and legislature. And then in the spring, you have an internship in Trenton in the state government in various different departments. If you're interested in education, if you're interested in legislation, you could end up in the speaker's office working there. And it's more than just working in a district office for for somebody from your district, you really get to dig in and see how laws happen and what are all the little bits and pieces that have to happen before a law, a piece of legislation moves slowly through that system and becomes law. So it is something that a lot of our students have taken advantage of, and it has propelled some of them into working in federal and state government in those levels and trying to push ahead and understanding how all of those work. And every state is different. Every state legislature is different, and everything happens really on a local level. When you talk about who gets elected and ends up in those chairs and running the states, it's all on a local level. And so sometimes the best thing that you can do is also getting involved in your local government and pushing for local people to get elected that believe in everything that we've been talking about. And all of it starts very small and then builds from there. Any other questions? We've got a couple more minutes. Or any last thoughts?
Yeah, I actually wanted to just sort of put on the table. So I went to law school with the intention of being a public interest lawyer. And I ended up in law school being able to have a number of just really fantastic experiences at different organizations. And that's the thing that I will say over and over and over again, that the beauty of law school is getting as much experience as you can in different types of environments, right? Because learning what you like and who you like to work with is as important as learning what you don't like and who you don't want to work with, right? And those are things that you figure out by actually having experiences with people. So, I did an internship at the ACLU and their women's rights project. I did an internship at an organization called the Center for Reproductive Law and Policy. I worked at the Legal Aid Society in their juvenile rights division. I worked at the HIV Law Project. And so when that's the kind of work that you want to do, your path through law school often looks really different than other people. And one of the things that is, if you're trying to build a career, either in reproductive rights or reproductive justice work, or just in public interest work, one, we have really great folks here to help people sort of build those careers. But one piece of that is that often fellowships are really important for people who are graduating and going into public interest work. And there are some, like the Skadden Fellowship, that's just, very, very prestigious. And then there's, Equal Justice Works, and there's, all these other sort of foundations. And then there are also some that are very specific to doing reproductive rights or reproductive justice work or women's rights work or sex equality work. And so that's one of the ways that you are able to create a career that is on a different track than people often think about, right, in law school. And it's a track that is often on a different timetable, right? So I remember being in my third year, and all of us public interest people were like, we don't have jobs yet. And the law firm people were like, I've had a job since second summer, So it can be a really difficult experience. And so it's nice to be at a place where there are a number of people who are interested in the same things that you're interested in, who are on a different track in terms of what they're going to do after law school, and where there is support at multiple levels for building a career that's a little bit different than what most people are doing. I'm guessing you have some thoughts about that, Kate.
That sounds entirely spot on. And I just really want to emphasize, get involved in a student organization, whether that's the Federalist Society or If When How, like totally different ends of the spectrum, because that is going to create a professional network for you. The first attorney who hired me was a former If When How fellow, and that's how she got her first legal job. And now the fellowship that I'm waiting to hear back from is the If When How fellowship. And obviously, like, I started the If When How chapter here at Camden, so it's all cyclical. Get your foot in the door with a student organization, build your professional network with your professors. Dean Mutcherson was my recommender for the fellowship, and you've got your network going there from your student org and from your professors. So yeah, and I agree with everything else that Dean Mutcherson said. Your timeline is going to look different if you're interested in public interest, but it's better for y'all to find that out now, very early on than less than 70 days before graduation.
And I'm also going to put a plug in for another session that we're going to have on March 24th at 12 o'clock on pro bono and public interest fellowships and experiential learning. Jill Friedman, who is the dean in Camden that works in the pro bono public interest area, Susan Feathers, who's the assistant dean in Newark, who works in the area, and also Professor Andy Rosner, who in Newark supervises all the externships, our trial team. He does a whole lot and teaches on top of all that. We'll be presenting a really wonderful program on those areas and all of the things that we can help you with and offer to you. So I think we're at the end of our time. I appreciate all of that you do and all the work that you're doing in the area. I know it's hard and frustrating. It's when we think that we've reached a point where everything is okay, and then all of a sudden the onion starts to get peeled back, and we're wondering, where is it all going? And it's happening on a lot of different levels right now.
Yeah.
So it requires a lot of vigilance. It requires, again, working local and making sure that where we are, things are moving in the way we would like them to move. And for all of you students who are here, I hope that you see how powerful that law degree is and how much you can do with it and how far you can take things if you stick with it. There'll be times that it'll be frustrating, but there will be times when there'll be a lot of wonderful things that will happen. So thank you all. We will post this up on our website in a day or two. And thank you so much, Dean Mutcherson and Kate, for being here today and sharing all of your experiences with us.
And Kate and I both put our contact information in the chat, so feel free to reach out to us as well.
Thank you. And you can always reach out to me and we'll forward it on. Thank you, everyone. So long.
Take care, everybody.